webinar, Consumer Lending and CFPB Regulation in the Biden-Harris Era. All participants are in listen-only mode. You're encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Patrick Kennedy. Patrick, you may begin.
Thank you, and good morning, good afternoon to everybody out there. We welcome you to Seyfarth Shaw's webinar series. Today we're going to be presenting on the consumer lending and CFPB regulation in the Biden-Harris era. This is the first of a series of webinars that we plan for 2021 being presented by the Consumer Financial Services Litigation Practice at Seyfarth Shaw. We think we have a good and timely and informative subject area to talk about today in the webinar series that we're planning throughout the year. We hope that you enjoy today's webinar and that you'll join us for our other webinars in the series. Some of the other subjects that will be upcoming in future months include the recently released CFPB report and recommendations. We're going to do a full seminar on that, as well as the new debt collection regulations under the Fair Debt Collection Practices Act, and also student loans issues and other issues related to the student lending industry, as well as a whole bunch of other timely and informative subject areas. In the next slide, we have present today's, well, this is a legal disclaimer that we have to present you, but beyond this, we have 3 presenters today. They include David Bazar, who's the chair of the National Consumer Financial Services Litigation Practice Group here at Seyfarth Shaw. He practices primarily out of the Boston office and covers a host of states in the Northeast. Tanya Esposito is also with us today. She practices primarily out of the firm's Washington, D.C. office and has a practice that covers a multitude of states in the Atlantic region of the country. And I'm here as well. I practice in the Consumer Financial Litigation Practice Group at Seyfarth, and I also practice in the Northeast states, primarily out of the Boston office. In the next slide, we have the agenda for today's webinar. And the first stop on the agenda is David's going to present and talk about some major legislative, regulatory, and enforcement and executive actions that are likely to be prioritized for consumer financial services by the Biden-Harris administration. After David talks about that, he's going to turn it over to Tanya, who's going to present on the Biden-Harris administration's financial regulatory agency appointments, including Rohit Chopra to head the CFPB, and a few others, as well as their backgrounds and what that could mean for change in the coming years. And then lastly, she's going to turn it back over to me, and I'm going to talk about primarily the status of the federal foreclosure and eviction moratoria, which has been the major impact on consumer services litigation during COVID. So with that, let me turn it over to David and get this webinar started. Thanks.
Thank you, Patrick. So from here, we'll go to the next slide, please. So everybody on this webinar, I imagine, knows about the CARES Act and probably knows that it's also been extended through June 30. What we're likely to see coming up is a lot of focus on what's going to happen with continued mortgage forbearances and the foreclosure and eviction moratoria. I'm not going to talk in depth about those subjects at this moment because Patrick is going to cover them when he gets to his piece. But just briefly to report on them, you know, those June dates are not likely to hold. Most likely, based on chatterings at the Congress and executive level, we'll probably see those slip back, I think, until at least September. But as of right now, we're looking at them through June. And of course, you know, all bets are off if the COVID strains that are circulating right now that folks are worried about maybe aren't as effective with the vaccine and those vaccines need to be adjusted, or we have other problems, this type of thing could be pushed back further. Another thing that we've seen, sorry, just go back to the prior slide, please. Another thing that we've seen, the focus, and will continue to be a focus, is on credit reporting. And as we all know, the Fair Credit Reporting Act was amended by the CARES Act to require all consumer debt obligation payments that were impacted by COVID. And by impacted by COVID, all that means is that the consumer says so, is to be reported as current or otherwise.
It looks like we have. Can we go on to the next? It looks like David's having some issues here.
Okay, I'm going to jump in here. If you go back, oh, maybe we have David back. Are you back, David? If we could go back to the first legislative initiative slide, Kelly. Part of the key provisions of the CARES Act, obviously impacting the mortgage and banking industries, was the forbearance of mortgage payments. And what we're seeing now is that forbearance is continuing at least through June 30th, or it can be allowed to continue for federally backed mortgages at least through June 30th by selection of the borrower. And so obviously that's had huge impacts on mortgage servicing issues. That's had huge impacts on default servicing for mortgages that are in default. Essentially, what COVID has done and what the legislation has done, including the extensions, is allow borrowers to put off their mortgage payments for months, and not allowed the servicer or owner of the loan to pursue remedies that might be available because of the default situation. So, absent some major change, we're expecting that the forbearance provisions to be in place at least through June 30th and perhaps through September, the end of September. That's impacted servicing, that's impacted default litigation, that's impacted default servicing, and will continue to be a major topic of discussion and consideration throughout 2021. David had just touched on credit reporting and the FCRA amendment by CARES Act requiring debt obligation payments impacted by COVID to be reported as current or otherwise as they stood pre-COVID. So those provisions remain in place through June 30th as well. Essentially, what that means is everything's on hold with regard to the debt reporting with regard to consumer debt and the impacts by COVID. David, are you back?
I think so. Can you hear me?
Yep.
I had to, sorry about that, little technical difficulties. My audio went out and I had to log back in through a different audio pathway.
Okay, I just hit a few more of the bases on the first slide. So maybe we can shift to the second slide, which I think is where you were at.
Perfect. Thank you, Patrick. Again, sorry about that. The joys of working from home. Okay, so another thing you have to be kind of hard to miss these days is all the talk of the $1.9 trillion stimulus package, which is referred to as the American Rescue Plan. It's not yet passed. It is actively moving. The House Budget Committee just advanced it through their committee. It's and we've got the latest here in terms of what its components are, at least in terms of whole dollar values. These are a little bit different than was originally announced in the plan as it's come out of the Budget Committee. Some of the amounts have been lowered a bit. So now, but not the stimulus payments. So the stimulus direct payments to individuals are still $14 per person. Now that's in addition to the $600 that was given out earlier. So that's the $2,000 you've all been hearing about. And then there are the phase outs where if you get the full amount, if an individual is earning less than 75,000 a year and a married couple for 150, and then it phases out at top levels of 100 for individuals and families at 200,000. That money is just earmarked for people, so they can choose to spend it on their debts, they can choose to save it, they can choose to do whatever they want with it. It is, however, money that is potentially available, as I mentioned, for debts. So I'm sure we'll see a lot of activity there. We've seen some interesting threatened enforcement actions over whether stimulus type payments, government payments, can be the subject of attachments by creditors, and a number of the more aggressive regulators taking the position that that's an unfair or deceptive trade practice under their laws. So something to think about if you're looking at potentially grabbing that money as opposed to asking for payment. And of course, you wouldn't know what's in somebody's bank account. So when you go and exercise an attachment, you don't know and you can't know where the funds came from. Also, we're looking at 19.1 billion in rental assistance funds. That number's down a little bit, and also funds for the mortgage assistance, and 5 billion for help in paying renters' utility bills. So, what that really means for those in our constituency is, oftentimes we have the most difficulties, particularly with litigation, when debt becomes distressed. Borrowers become desperate and they strike back either pro se or through lawyers. When they're swimming in cash and they're not worried about these issues, or at least they're not as imminent, there's less litigation. And so the longer that the government continues to pump money into the economy, the more we will see the forestalling of consumer bankruptcies and consumer driven litigation in the debt field. Next slide, please. And Tanya's going to cover the CFPB agenda in more detail, so I'm only going to briefly touch on these topics. Just a couple of things to pay attention to. The Supreme Court's 2020 decision in Seal of Law versus the CFPB, as we all know, gave the president authority to change the CFPB director at will, and that was exercised as quickly as it could be. So we have a new CFPB director, Kathy Kraninger's out, and Rohit Chopra is in. Tanya's going to talk about Rohit Chopra and the differences that we're likely to see there, and they will be profound. Next slide, please. And one of those is going to be on fair lending initiatives. Disparate impact is going to be back and with a vengeance. The disparate impact being no intent required. It just has the impact of unfairly prejudicing minorities' abilities to get loans. And that typically starts at origination mortgage here, but this could be any kind of loan, car loan, any loan where some type of underwriting criteria is applied to determine who is eligible for it. We're going to see the CFPB step up its fair lending activity at every level. Origination, servicing, debt collection, and for every type of loan product that's out there. Next slide, please. So one of them, for example, is ECOA, the Equal Credit Opportunity Act. Certainly see an increased enforcement action in that arena. Will we see rescission of the rescission of the payday lending underwriting rule? That'll be one to watch. Will we see implementation or amendment of final FDCPA rules? Maxine Waters and her committee are pushing hard for that, and have written a letter to Biden requesting, among other things, that the FDCPA rules that were recently put out by the CFPB be rescinded. That can only happen through a notice and comment. If it's going to be done by the CFPB itself, because these were promulgated pursuant to notice and comment. It will be interesting to watch to see if these rules are tweaked or rescinded in total. We're going to watch the OCC's True Lender Rule with regard to the Southern District of New York challenge that was brought by New York, California, and other states just recently, last month, where they're arguing that the OCC rule is ultra vires. What the true lender rule deals with is, so let's say you're a small business, like maybe you're a fintech, you are trying to be able to lend money to consumers. You don't have the infrastructure to do that yourself. So you go out and you hire a bank to go ahead and create the infrastructure to do the lending product. The true lender rule has to do with whether or not if the business as opposed to the bank keeps ownership control, effectively does everything, and the bank just sort of lends its name to the lending, or does a little bit more than that, but not enough where the bank is really acting as the true lender. The issue is this a circumstance that the regulators or state laws will forbid? The OCC stepped in and said, we're fine with banks lending in this manner as long as the bank's the lender and everything's disclosed properly. But we have got a federal court challenge that this is going to get tested in. FinTech, the Telephone Consumer Protection Act, student lending, credit and prepaid auto cards, auto lending, all of these areas we're going to see increased regulatory and enforcement activity for sure, given the change in leadership. And the simple question will be, by how much? We all remember prior to the CFPB coming into existence, that the reason that it came into existence was that there was a lot of talk about how there was lax oversight at the federal level, particularly on the enforcement side. When they created the CFPB, it took a long time for the CFPB to put out the regulations that it was going to put out. And what did it do in that time period? It regulated, regulated through enforcement activity. It would go and target specific lenders. It would hit them hard with some type of enforcement action, and then it would seek to create the legislation, effectively the regulatory framework, through scaring everybody else that this would happen to them if they didn't comply with whatever manner the CFPB was stating that the target of its investigation and enforcement action should have complied. Will we see more of that this time around until the CFPB is able to get through notice and comment for new regulations, which can take quite some time? And I believe we will. Next slide, please. We're also seeing a lot of executive action by President Biden. We've seen the federal student loan interest free period extended through at least September 2021 with no enforcement. In the scheme of just an interesting aside here of the no good deed tends to go unpunished. There have been litigations now over whether student lenders' decisions to simply stop auto draw payments on students paying their loans down in this time period are unfair trade practices, and in one instance, the complete cutoff of a student's ability to pay, like you couldn't go on the website and actually even make a payment voluntarily. And is that some type of unfair or deceptive trade practice or violative of some other law or regulation? Is an interesting area where we've already seen litigation and will expect to see more. Pumping potentially more money into the economy. We've got talk about possible federal student debt cancellation of up to $50,000. I think President Biden's been talking about maybe $10,000. Others have been pushing for $50,000. How much relief will we see there and when? And then of course federal student loan servicing. Those payments made between March 2020 and September 21 must be applied to principal. That goes back to my first point about, well, what's the punishment for? It's, well, to the extent that borrowers can pay their principal down, does that benefit them in various ways, even though they're not being required to make any monthly payments, and even though it's interest-free, is where folks are focusing there. Next slide, please. So with that, I'm going to turn it over to Tanya.
Great. Thank you, David. And thanks, everyone, for joining us today. So as David mentioned, I'm going to spend a little bit of time just talking about the appointees that are going to take key positions that will have an effect on consumer lending. And there are many folks that, we could have highlighted today, but we picked a few of the most impactful. So starting with Rohit Chopra. So, he was previously the assistant director of the CFPB, and in fact, after Dodd-Frank was passed, he actually joined the Department of Treasury to launch the CFPB. So he's been there, or he was there at its inception, I should say. And so in that capacity as director, he oversaw the agency's student loan agenda, and he was subsequently confirmed as an FTC commissioner in 2018. And in that capacity, he focused a good amount of his time on big tech companies that pose risk to privacy, national security, and overall competition issues. But again, in that capacity as to student loans, he was a fierce critic of how servicers handled struggling borrowers and made many comments and wrote extensively on that issue. So to David's point, we anticipate seeing more of the same as he's, set to lead the CFPB and the Biden-Harris administration. He's also had several controversial dissenting votes while at the FTC as a commissioner, one of which involves a very prominent online communications platform that I won't mention by name because, candidly, I have not run this through our conflicts, and I don't want to get myself in trouble. But in February of 2021, the FTC announced a settlement with this particular communications platform, and it addressed the FTC's allegations that this particular company misled consumers about the security of this platform. And the order issued by the FTC, among other things, prohibited this company from making privacy and data security promises to consumers that the FTC felt it could not keep. And the final order actually has some remedial requirements in terms of a remedial program that requires this company to develop, document, and implement a very comprehensive 10-point data security compliance management system. And this company has also been ordered to dedicate qualified personnel to evaluate these proposed new offerings, but no monetary fine or penalty was assessed in connection with this order. And so Commissioner Chopra was one of two dissenting votes, and in his statement, and I'm going to quote a little bit from it, he said that he voted against the, quote, weak settlement due to, quote, an alarm for the public when the proposed settlement was released for comment. He disclosed that, unbeknownst to the public during the comment period, this company's business practices and access controls allowed the People's Republic of China to get access to user data. And he went on to criticize the paperwork requirements ordered by this, that are in effect because of this FTC order, and also disappointment with the FTC generally, which, in his words, is an enforcer and a government agency that should listen to the public. And so clearly that was one dissenting opinion that gives us some insight as to the approach that we anticipate Chopra to take as he leads the CFPB over at least the next 4 years. So, it's no secret that we're going to see a more aggressive approach to how banks, lenders, and debt collectors treat their customers. We're likely to see an expectation of heightened transparency in the compliance process, where companies are handling consumer data and making any kind of privacy promises. And Chopra is also likely to expect companies that violate consumer protection laws to provide some form of recourse to the consumer. And perhaps overall, it's likely that he's going to expect that all government agencies are taking into account generally what the public has to say on all of these issues. And, because the CFPB structure gives its director unilateral power over its activities, the agency is largely defined by the priorities of its leader. And so this has led the agency to being highly criticized and politicized by both ends of the political spectrum, whether it be that the agency has been too aggressive or too lax. And so, it would be unlikely that that sort of dynamic is discontinued, or said another way, I would anticipate that we'll continue to see the agency be perceived as highly political as we move forward. Next slide, please. So moving to SEC Director Gary Gensler, who is President Biden's pick for Director of the Securities and Exchange Commission. Gensler is known as a reformist and also as an aggressive protector of consumer protections, and someone who does not hesitate to engage in climate change and reform. He currently teaches at MIT about cryptocurrency and blockchain, so closer scrutiny of these digital currencies is certainly likely. Many expect that Gensler will effectuate policy changes that include requiring companies to disclose more information about their risk, as well as political contributions, boardroom diversity, and share repurchase conditions. And it's important to note that as head of the CFTC, Gensler led a regulatory crackdown on Wall Street for abuses in setting benchmark interest rates. And so these cases led to record fines. So again, we see a track record of aggressive enforcement and someone who is dedicated to affecting change, and we certainly expect more of the same if he's confirmed as the SEC director. Next slide, please. And finally, Janet Yellen, who has been confirmed as the Secretary of Treasury. She was confirmed on January 25th by a landslide, and she, of course, has incredible experience as part of the Federal Reserve Board and otherwise. What can we expect from Janet Yellen? Well, in 2019, she wrote a letter to then Secretary of the Treasury, Mnuchin, urging him not to move forward with plans to relax oversight on big financial firms and warning that doing so could threaten the stability of America's financial system. And later in 2020, she expressed her desire for what she called a new Dodd-Frank at a Brookings Institute event, noting that existing laws are insufficient for dealing with problems in what she called the shadow banking sector that has emerged when the pandemic caused severe market turmoil. So that's just a little bit of insight as to, her thoughts about where we need to go in the immediate future. But in terms of anticipated economic policy, her track record at the Fed includes implementing rules-based policy as well as more transparency. And this is certainly what's expected of her leadership as Secretary of Treasury. Although she will have a wider range of responsibilities now, including involvement with international policy. And so on the banking front, the question is, how hard will she push for regulation? And some of the things that she'll likely be considering is tax reform, international trade issues, and considering things that are working to potentially move in a direction or a new direction, I should say, where they are not perceived as working. And this, again, is not just in the domestic realm, but internationally, because she will, as Treasury Secretary, have a seat on the National Security Council. So that will play an integral role in these issues. And of course, it's important to note that this includes the existing tariffs on China, and what her plan is there remains to be seen. But again, it affects not only our domestic financial policy, but our global supply chain, and the need to establish good relationships on the economic side internationally. Next slide, please. So I think the key takeaways, if they aren't obvious already, is that these individuals are very smart and very, very experienced. They all have a track record that we can point to and it's verifiable. And so we have an understanding of how they approach governing and what's likely to come out of their leadership. They're all very consumer focused. And I think that we can expect them to be aggressive and for there to be a lot of shakeup by way of either reversing things that occurred during the Trump administration or effectuating new regulation to sort of take us in a different direction, one that is certainly more consumer focused. Next slide, please. With that, I'm going to turn it over to Patrick.
Thank you, Tanya. Obviously, the agency heads and key appointees by President Biden and Vice President Harris are going to have a huge impact on the going forward business of banks and financial institutions. And it's going to be a wait and see, but I expect we're going to see a lot happen in the first year. It's kind of poignant that we're sitting here in the last week of February 2021. A year ago, the last week of February 2020 was essentially the last week of normalcy, if you could call it that. The COVID onset had already started overseas. It had come to the United States by January of 2020. And the first declaration of a state of emergency by the federal government, I believe, was on March 1, 2020. So here we are a year later, having lived in, some people call it the new normal. I'm hoping that it's just a temporary and temporarily ending normal, and that we can, at some point in 2021, shortly, get on with some of the way our lives were before the pandemic struck. But this section of the webinar is going to really explore the major impact of COVID on default servicing in the mortgage and property arena, which has been the federal foreclosure and eviction moratoria. So we had the onset of COVID in early 2020, and that led to a state of emergency in March of 2020. And what did that lead to? That led to an immediate concern throughout state and federal governments throughout the world, but especially in the United States, where we are practicing, about housing security. And the response to major concerns about housing security were, what do we do to make sure that people aren't displaced? So an immediate effort was put in place by the federal government as well as states to enact what became known as the eviction and foreclosure moratoria. So in the states in which we practice, and states all across the country, you need to be concerned with, if you're wanting to proceed on default remedies in loan documents or in lease documents, you need to be concerned about what restrictions have been put in place because of COVID that could limit my remedies or the timing of my remedies. And those come from both state and federal sources. Generally, the federal restrictions are going to take precedence over state moratoria unless the state restrictions are more restrictive. So lesson one is you got to check state and federal law before proceeding. And generally, federal law will prevail, and you got to follow federal law unless states are more restrictive. Now, states have taken different paths. We can't cover all of those. David and I practice in some New England and Northeast states. Tanya practices in DC, I believe Florida, Maryland. Here in Massachusetts, what happened was the state legislature almost immediately went into crisis resolution mode and adopted a law very quickly that was called the Mass Eviction and Mortgage Foreclosure Moratorium Act. And that essentially put in place a halt on all eviction and foreclosure activities by banks and landlords, with some exceptions. It stopped new cases, it stopped existing cases, and it essentially, the way the Mass legislature went about it was they put in place, not knowing how long the COVID state of emergency would last, they put in place a temporary eviction and foreclosure moratorium that would last 120 days, or they specifically said it would last for 120 days or until 45 days after the COVID state of emergency was ended by the governor of Massachusetts, whichever came sooner. But they also put in that law state law, a provision that the governor of Massachusetts could extend it essentially by governor action, by executive action, for periods up to 90 days or longer. So he could do 90 days, and then when that 90-day period ended, he could extend it another 90 days. Ad infinitum, no limitation, with the cutoff being 45 days after this COVID-19 state of emergency ended. What happened in Massachusetts was the governor, in fact, extended the eviction and foreclosure moratorium under state law, but he only did it for 60 days. And when that time period, that 60-day extension expired in October of 2020, he let the eviction and foreclosure moratorium end. The state law eviction and foreclosure moratoria came to a conclusion. But, and lots of other states have taken similar paths. In some states, it's been by legislative act. In some states, it's been by executive action. In most states that I'm aware of by now, many of the absolute bars on proceeding with new cases or proceeding with existing cases has come to somewhat of an end. But that doesn't mean that the eviction and foreclosure moratoria are at an end altogether, because we still have the federal restrictions. So on the next slide, we have, so where do these federal restrictions come from? They've come from several different, they originally came from the CARES Act. CARES Act gave the government authority to enact measures that would allow for housing security and protection during COVID-19. But then they came from different sources based on reasons that, for example, a federal agency might have, or a source of authority that they might have to put protections in place for people who live in houses with, for example, federally backed mortgages. One of the major moratoria that's been in place since the fall, September of 2020, has been the CDC's eviction moratorium. That's the Federal Centers for Disease Control, and that's based on health findings by the CDC experts in the federal government. They essentially put in place that eviction moratorium. It's been extended several times. It was originally put in place for 90 days. It was 90 or 120 days. It was extended by the Trump administration in the legislation that funded the government at the tail end of 2020. And it's been extended since then in increments, so that it's going to be in place now at least through June of 2020, but more likely further extended, as all of these are likely to be further extended at least until September of 2021, if not longer. GSEs have their own moratoria. The GSEs, as folks know, is the agency that, or the Federal Housing Finance Agency is the agency that controls Freddie Mac and Fannie Mae, which are the GSEs that hold many guarantees and ownership of mortgages throughout the United States. I think something like 65 to 70% of mortgages in the United States have some federal backing. The GSEs have, through FHFA, Freddie Mac and Fannie Mae, have enacted moratoria on foreclosing on mortgages backed by those GSEs, as well as eviction moratoria on REO properties, real estate owned properties that came into ownership through the foreclosure or default remedy servicing of a property that was backed by a GSE mortgage. There are also other federal agencies that have backing of federal mortgages that have their own eviction and foreclosure moratoria. Those include the Department of Agriculture and the Department of Veteran Affairs, as well as HUD, which has control over FHA-backed mortgages and REO properties that arose from default servicing on FHA-backed mortgages. On the next slide, we show the recent extensions of some of these moratoria. One such recent extension was at the end of the Trump administration. And with the inauguration of Biden-Harris administration in January, all of the moratoria, the federal moratoria, which had been scheduled to expire by March 1, have now been further extended. So in early February, the foreclosure moratorium by the GSEs was extended through March 31, 2021. That's obviously for Freddie Mac and Fannie Mae backed mortgages. And how do they do that? I was interested in this myself. Essentially the way Freddie Mac and Fannie Mae direct their servicers to incorporate servicing changes is through lender letters and guide bulletins. So Fannie Mae issued a lender letter in early February of this month to all servicers of its mortgage, indicating that the moratoria would be extended through March 31, 2021. Freddie Mac issued a new guide bulletin on February 10th. It supplemented its servicing guide, also extending the foreclosure moratoria through March 31, 2021. We expect very shortly now that these will be formally extended by the GSEs, Freddie Mac and Fannie Mae, through further lender letters and through further guide bulletins through June 30, 2021, because of a Biden-Harris announcement, essentially an executive agency action with an announcement letter that was announced through the same portal on the Biden-Harris website that executive orders are announced. They announced an extension of these federal foreclosure moratoria and eviction moratoria through June 30, 2021. I note as well that the payment forbearance availability has already been extended by the GSEs, and that was done through their Fannie Mae lender letter and Freddie Mac guide bulletin that were issued back earlier in February of this month, so that forbearance availability for borrowers who've been impacted by COVID, there's an availability to essentially just request forbearance, and that forbearance need only be documented through a request letter. It's very informal. There's no need for a sworn affidavit. There's no need for documentation that proves up how COVID has impacted a borrower's ability to pay. They can simply ask for it as informally as through a phone call, through an email, through a letter, and request mortgage payment forbearance. And that is based on COVID and COVID impact, and the servicer for these GSE-backed mortgages is required to provide it. On the next slide, the CDC order extending the federal eviction moratorium from the end of January was taken through March 31, 2021. That was announced by the new CDC director on the date of the Biden-Harris commencement. So the new CDC director came in with the onset of the Biden-Harris administration, and immediately one of her first tasks apparently was to extend the CDC eviction order, which was at that point in time was only extended through the end of January, and that was extended through the end of March at this point in time. As I mentioned before, there was an announcement by the Biden-Harris administration on February 16th that the federal foreclosure moratoria and eviction moratoria would be extended through the end of June, and that will cover all of the sources of eviction and foreclosure moratoria that exist within the federal government. The HUD, FHA-backed mortgages, Department of Veterans Affairs backed mortgages, Department of Agricultural backed mortgages, and then the GSEs through further amendments to the servicing guides and lender letters that we expect shortly. On the next slide, I just want to touch on what exactly does that mean? What does the foreclosure moratorium prevent? Absent a limited number of exceptions. The foreclosure moratorium, federal foreclosure moratorium, essentially means that lenders for these federally backed mortgages cannot initiate a judicial or non-judicial foreclosure of single-family properties. They cannot move in judicial foreclosure states for a foreclosure judgment. They cannot notice non-judicial foreclosures and non-judicial foreclosure states. They can't proceed with sales of properties that were in midst of foreclosure before any moratoria were put in place. They can't notice new sales. They can't proceed with previously noticed sales. Essentially, for these covered mortgages, everything is on hold with regard to foreclosure. Now, the exceptions, the express exceptions that have arisen in the specific foreclosure moratorium and bans are for vacant and abandoned properties. So if a property is can be documented as being vacant or being abandoned, then that's an exception that can allow for an existing foreclosure to go forward or for a new foreclosure to be commenced, whether that be by judicial process in judicial foreclosure states or by noticing a non-judicial foreclosure in those states that have non-judicial foreclosure. On the next slide, we see that there's an impact on mortgage debt. There's an impact on mortgage servicing. We've had a year, almost a year, where covered mortgages essentially haven't been able to get into foreclosure, and the lender's remedy has been severely restricted. What they don't do is they don't eliminate debt. The mortgage forbearances do not reduce or impact the debt, both principal and interest, from accruing. They don't give a get out of your loan free card. Generally, servicers are required to come to some agreement with the mortgagor on treatment of missed payments that are caused by COVID-19. And the way that that's been talked about, if not expressly provided for in regulations yet, is will that debt be added to the end of the mortgage? And because mortgagors and services are still owed the full amount of the principal and interest, these moratoria really impact the timing of the default remedy of foreclosure that ordinarily banks and servicers would exercise within a reasonable time after default ensued or uncured default ensued. We anticipate there's going to be tons of litigation on how banks and mortgage servicers treat debt that was put into forbearance once the foreclosure crisis or the moratoria end. It's going to be very difficult, we think, for borrowers and their servicing lenders to come to an agreement that fits both sides. So we're already seeing that there's been litigation over banks and servicers that put borrowers into forbearance, even though they may have not requested it, or there was some vague inquiry about what are the impacts of COVID, and a forbearance went into place. And we've seen that there's been a ton of litigation over that. So there's going to be even more litigation over how to treat and how to deal with all of these missed payments, all of the accruing interest, all of the lost time that has ensued since the foreclosure moratoria went into place almost a year ago. We think that once the foreclosure moratoria come to an end, there's going to be a huge number of mortgage loans in default that's going to result in a very large number of both non-judicial and judicial foreclosures, as well as servicing disputes and litigation over servicing disputes due to the delayed access to foreclosure remedies during this time period. On the next slide, a little bit on the eviction moratoriums and what do they prevent? Absent exceptions, landlords or owners of REO properties that came into ownership by servicers of banks through default remedies cannot initiate or obtain judgments in eviction proceedings with regard to COVID impacted tenants. And in order to access relief, tenants are just required to complete a form and submit it to their landlord certifying a COVID-related impact. And that essentially will allow a tenant to remain in the property during the eviction moratorium that was put in place by the CDC. It does not eliminate the requirement of the tenant to pay rent. That's explicit in the CDC eviction moratorium order, but it obviously dramatically impacts the timing of default remedies to obtain possession of the premises and to relet the property to paying tenants. It's resulted obviously in, for small landlords, difficulty in making mortgage payments. If small landlords aren't being paid by their tenants, that could result in defaults and perhaps forbearance under COVID. So there's kind of a cascading effect here of the eviction moratorium, how that can impact the owners of the properties, whether that be a bank or a commercial landlord. There are large numbers of rental and mortgage payment assistance programs that are being discussed, large sums of money being talked about. I know in Massachusetts, there's been state-based funds that have been put in place in order to allow both tenants to access by completing forms and submitting applications for rental assistance. There's also landlord assistance funds as well in Massachusetts. And on a state-by-state basis, there's probably a lot of these funds that are going to provide some relief in the short term. And the large sums being talked about in the by the Biden administration, $25 billion, for example, for landlord and or home ownership assistance during the early stages of the Biden administration. If that passes, that's going to provide large sums of money that may be accessed in order to stem the tide for some time being. And that's sort of with that, I'm sort of coming to a conclusion on where we stand in terms of the status of the foreclosure and eviction moratorium and where we stand. I see that there are some, well, actually there are not any questions and answers that have come up. If anyone in the audience has any questions that they want to type into the Q&A portal, we'll be here for a few more minutes and available to answer any questions that do come up. But I want to thank everybody for joining us today. David or Tanya, if you have any closing thoughts, now's the time.
Yeah, I would just add that, as you mentioned when we began, this is going to be a monthly series where we're going to touch upon some of the, hot topics and developments in real time. And so we encourage everyone to, if you haven't, subscribe to our mailing list. And if you need information on how to do that, please reach out. We're happy to provide that. But we have a pretty good roster of presenters and great material coming up over the next several months. So we encourage everyone to join us again.
I'll just chime in on just a sort of a parting thought. I recently spoke on another panel with a senior lawyer from Fannie Mae, and one of the interesting comments that he made that they were concerned about over there is the hollowing out of the infrastructure and how we should all be thoughtful about that and preparing for all this future. Everything that we just talked about right now, all of our organizations, both inside of them and on the vendors that they use, have had some shifts in their workloads. Some of the types of things that we're really used to doing in our routine, we don't do anymore. We've stopped doing them, and in some instances, the personnel who did them are not there anymore. And so Fannie Mae has been voicing a concern that when this all spools back up again, and it may spool up again pretty quickly, will we each have the infrastructures there to manage the risks and the problems that we're going to encounter, and how we can be thoughtful about that. And a couple of the points that he made that I'll just pass on to you are just some of the basics, like, you know, how's your default servicing working? And are you monitoring it in the same way? And are you still doing things like routinely endorsing notes where there's been an ownership transfer, or there's about to be an ownership transfer? The types of things that can cause problems down the road when they're not attended to. So just as my parting thought, I'll pass along what I heard that I thought was really valuable to think about those issues now, or it's too late.
Okay, with that, I think we'll give everybody back 5 minutes of their day. We want to thank you all for attending today. And as this last slide shows, we're all available by email, by phone, to help troubleshoot any issues or problems that any attendee may have, or any follow-up questions that you may want to pose. Once again, thank you. Appreciate your attendance today.
Here's the CLE code for anybody that's looking for CLE credit. It is SS3497, SS3497. Thanks.
Thank you.
Thank you.
Everyone.